Thank you everyone for attending our morning session, When Disaster Strikes, in Insider's View. I'm Isaac Rothschild. I'm a member of the Conference Executive Committee. We are going to do a series of TED Talks. We anticipate that there will be time for questions afterwards, so there are forms on your table. If you fill those out and hold those up, members of the wonderful Ninth Circuit team will come by and pick those up. Our first TED Talk is going to be from Lexi Hazam. Lexi is the lead partner of the Mass Tort Division of Lieff Cabraser. She's nationally recognized as lead counsel on various mass tort actions and also as an elite trial lawyer. Due to her key role in the Tomsey, Woolsey fires, PG&E, San Francisco Wine Country fires, the Orange County pipeline ruptures, more than $1 billion have been recovered for victims. Our second TED Talk will be presented by the Honorable Jay Gandhi. Judge Gandhi is at Phillips ADR. He spent 8 years as a magistrate judge in the Central District of California, where he was a hands-on trial judge and oversaw the district's ADR program. He's presided over $1 billion+ settlements, was active in the PG&E settlement, is known for his marathon mediations, worked with the Los Angeles Police Department on reforms post the George Floyd murder, and co-chaired the ABA's ADR Plus committee. Now I'll invite up the Honorable Charles Breyer.
Thank you. Good morning. It's my privilege to be able to introduce Ken Feinberg, the third person on the TED Talk. In 1984, Ken, who was the former chief counsel for the Senate Judiciary Committee under the leadership of Ted Kennedy, got a call from a legendary federal judge, Jack Weinstein. Now, Jack Weinstein was one of these real hands-on innovators. And he phones Ken and he said, "Ken, I want to appoint you as a special master for settlement purposes to deal with the Agent Orange case. It's particularly sensitive because, of course, it was the military that caused this problem, and the people who are the victims of Agent Orange are the veterans. So can you handle it?" And Ken said, "Well, Judge, of course, I'd be delighted to handle it, but what authority is there for your appointing me?" He said, "I've looked at the rules for special masters. There's nothing in the rule about a special master for settlement purposes." And Jack Weinstein said, "Look," he said, "I wrote the rules, and there's nothing in it that says you can't." So as a result, Ken was one of the very first special masters appointed for settlement purposes. Now, of course, the end of that particular tale is that Jack Weinstein retired prematurely at the age of 99. And it's looking more and more premature as I get older and older. But Ken went on to have a fantastic career as a settlement master. He was appointed and settled the British Petroleum, the oil spill. He's been appointed in over 24 archdiocese cases throughout the United States, several in this circuit, to resolve the claims of sexual abuse in those cases. He has worked on the settlement of the Volkswagen diesel case, of Judge Chen, his automotive case for Fiat and Chrysler, thereby allowing Judge Chen to take extended vacations. He also has been a settlement judge in the Monsanto case. Many, many cases that he has served as special master, but one above all has to be remembered by everyone in this country. And that is, he received a call from the White House shortly after 9/11, and it was from the president, and saying, "We want to appoint you as special master to resolve the compensation for victims of the 9/11. It was a bipartisan measure. And he was appointed. He represented them, and he did so without a fee. So I'm being timed off. Anyway, you came here to hear Ken Feinberg.
So I came to hear Ken Feinberg too, so I'll be brief. It's my honor to be here today and to speak to you all about the law of catastrophe. The word catastrophe, derived from the Greek, was originally used in drama to describe the final, often disastrous part of the play where the plot is resolved. In the real world, the resolution part is often in the distant future, if it ever comes. And the law of catastrophe is in some ways an oxymoron, because when a catastrophe occurs, law and order and justice can seem very distant. But in fact, the law and lawyers and courts do have an important role to play, which this panel is here to discuss. Before we do, I want to recognize that a number of people in this room have suffered losses in the massive wildfires in recent years, including losing their homes. I extend my deepest sympathy to you. For those of us spared this experience thus far, it is impossible to fully comprehend. We have a panelist who can speak to it today in ways that I can't. But it might help to hear a little bit about what it is like to represent people who've had this experience, what we hear from them. There may be stages that are often akin to those of grief: disbelief, shock and confusion, sadness, anger. There is often a dawning sense of just how attached we are to our homes and the things in them, often as a repository of memories and comfort as much as material things. There are also priceless sentimental items that people lose: photos, keepsakes. And of course, for many, it is also economically devastating because they are underinsured, especially in a market where construction costs are skyrocketing due to increased demand, because they are displaced and rents are also skyrocketing, and because just dealing with all the paperwork is so overwhelming that they may not be able to attend to their work. And then the lawyers arrive, and not always in the best way. Advertising can inundate and confuse. All of this affects what happens in litigation. It informs the pace of filings and of discovery. People are overwhelmed initially, and it takes a long time for them to gather proof. Think of trying to write down a list of everything you have in your home and how long that might take you. The losses mature over time. As you rebuild, the plans change, the prices change, your wage loss may continue. It also informs the approach to settlement and the willingness to settle of all parties. It's harder to settle if your damages are still evolving. It's harder to settle if the insurer is still making payments years later and may have its own independent claim. The number of claimants may affect whether bankruptcy might be in the works. The emotion involved, the anger I referred to, can motivate plaintiffs, at least victims, to go to trial. These generally, after all, are not cases where there is any contributive fault or alternative causes. And the intimate nature of the home and the losses makes many people want a highly individualized approach to their case. And yet, these things may be in tension with the need for compensation as quickly as possible, with the need to preserve and rebuild communities. Think of the very unique places that were Paradise, that were Lahaina, that were Altadena. We want to preserve the nature of those communities to the maximum extent possible. And there's the need for the defendants involved to determine whether they will remain solvent. So all of those things create time pressure that may be in tension with some of the things that can cause delay I referred to earlier. The things that create time pressure can favor accelerated or group proceedings in an attempt to move more quickly and efficiently. Given these tensions, what can and can't a court do? It's easier in many ways to say what a court can't do, unfortunately, or what a court can't control. The court can't control the size of the catastrophe. The court can't control the solvency of the defendants. The court can't control the jurisdictions involved. So it's not just a matter of state and federal, it can be a matter of the closest court may, among its own staff members, have suffered so many losses that there are conflicts that mean that cases may not be able to proceed there. Or court buildings themselves may have been affected. The court can't control what's happening on the legislative front and whether there are bailout bills that may pass and change the landscape. We had that after the massive wildfires in California in 2017 and 2018, and that legislation makes bankruptcy less of a risk, although it still exists. And the court can't control the number and type of filings. But there are very important things that the court can shape. The court can shape important things regarding scheduling and framing of the case. Setting trial dates. Setting trial dates early on for as early as possible can be very helpful to victims, although it of course has to be balanced against the ripening of damages and the need for the official investigation of the disaster to proceed. The court could consider liability trials that may be preclusive, either in the formal sense or as a practical matter. Mechanisms for doing this could include, in a class context, the use of Rule 23C4 for an issues trial. Could include bellwether cases, may not be preclusive formally, but may have that effect. The court could consider the potential for bench trials on some claims. Here in California, under California law, we have a claim called inverse condemnation. It's basically a variant of eminent domain, and it is brought almost universally by victims in wildfire claims against utilities. That can be tried to the bench, and that could mean for a faster trial. It does, however, forgo a community jury, which could be very important to the community. One way of doing it would be to have damages trials on other claims before a jury and bench trials on certain liability claims that can be tried to the bench. Also, appointing a mediator early is very important and can tend to make proceedings go more quickly and efficiently. That's particularly the case if there is a risk of bankruptcy. So in the Maui wildfires, mediators were appointed very early on, and that was very useful to the parties. The court can also think about different mechanisms that it has at its disposal to frame the case. There may be, in certain cases, both class and individual components to the litigation. Liability is usually the same between them, so liability can proceed as to both. They're not mutually exclusive. Sometimes the nature of the case changes its settlement. It might not be a class case, but it might resolve as a class case. A class approach may, in some circumstances, dampen aggressive advertising. We have seen it to date more often in oil spill cases than in wildfire cases. And a class, crucially, can offer finality to the defendants, even without a bankruptcy or without the statute of limitations expiring. Again, this was a key reason to have a class component in the Maui wildfire litigation and settlement. Sometimes you have cases proceeding in both state and federal court arising out of the same disaster. Again, that happened in the Maui wildfire, and so coordination between the state and federal judges is also very important and did occur with regards to the Maui wildfires. Functional leadership is another area where the court can have a large impact. These disasters involve thousands of claimants. They involve hundreds of lawyers. Having effective leadership to make the case proceed efficiently is very important. That leadership can take different forms. If it's a class case, it may be interim class counsel appointed under Rule 23. If it's a mass tort case, it could be mass tort lead or co-lead counsel, similar to the MDL model. That may involve common benefit. Or it could be a liaison counsel, a self-organization model. This last is actually the traditional way that wildfire cases were approached in California. It is changing a little bit, but it still occurs. It may avoid common benefit fees. At the same time, it could run a risk of a tragedy of the commons or disunity among counsel if they are not coordinating well. There's also the issue of the commitment of leadership over time, because these cases take years. The court can shape the role of subrogation counsel and how it coordinates with individual counsel. The most important thing is facilitating information sharing among subrogation plaintiffs and individual plaintiffs from the get-go. The individual plaintiffs need to know what have their insurers paid. The insurers need to know which of their insureds have brought suit because they have independent claims. The issue of who settles first is a big one in these cases. It's often subrogation because their damages are all clear dollars and cents. There's no emotional distress that is subjective where the value is in dispute. And they have models from many prior cases. They have proprietary software to calculate their damages. But if subrogation does not resolve first, and it doesn't always, then the court needs to anticipate and prepare for a lien process and made whole issues. This arose again in the Maui wildfire cases where subrogation did not settle before the individual plaintiffs reached a settlement in principle, and the state court judge is preparing for what may be thousands of lien hearings. And finally, there might be ways that courts could get very creative here that would really be helpful to victims and communities. These have been rarely, if ever, done, but could be very valuable. Workshops at the courthouse on how litigation works, on how dealing with insurance works. These could be led by NGOs like United Policyholders, provides this kind of information to victims. It could be tapped through victim lawyers so long as it is in a role that is education only. It might be useful for some prior victims to be involved. Workshops could also take place on FEMA or other forms of aid that might be available to victims sooner than they will receive compensation in their court case. Monitoring attorney advertising is important for the court and arguably within its powers. There have been recent bills passed in California to place some restrictions on attorney advertising, the Umberg bill. The court could facilitate pro bono representation of victims who don't otherwise have it. And there may be opportunities for victims to speak outside of trial, whether as part of formal proceedings or not. All of these could be creative mechanisms that a court could use to give voice to the victims, to make them feel like they are participating in the proceedings. Also, I will note that a number of courts, including the Northern District of California, have pilot public access via Zoom, via video conference. And I know that that has also been happening in the state court case arising out of the Altadena fires. And we have many clients who have tuned in each time to the court hearings, even though some of the legalese, et cetera, may be beyond them. It makes them feel like they are being heard. And so they have actually wanted to tune in to those sessions. In sum, while there may be many things outside of the control of the court, there are other ways in which it can have influence in ensuring fair and efficient proceedings in which victims are heard. Thank you.
Good morning, everyone. There we go, mic check, thank you. So nice to be back at the Ninth Circuit Conference, to see such old friends and make new ones. And today, I'll stand before you not just as a former colleague from the Central District of California and a present-day mediator and arbitrator, but I also stand before you as someone who's been seeking justice in the face of catastrophes. So let me take you on a journey. It's both personal and professional for me most recently. It's where the law intersects with disaster, where a rigid legal precedent must absorb the chaos of catastrophe. And it's the idea that perhaps, just perhaps, and you heard Lexi talk a little bit about it, is innovation in ADR might be the guide. So let me take you to the day that recently came, and I still get touched up about it. So that January 7th, Pacific Palisades, California. I left early that day. I couldn't be late. I was with Judge Carter, David O. Carter of the Central District in downtown Los Angeles. We're at the First Street Courthouse. It's a hearing on homelessness. Some would argue one of our nation's other great failures. I was the mediator and the special master for the plaintiff's settlement with the County of Los Angeles. The County of Los Angeles was going to provide 3,000 additional mental health beds, along with other contributions. And so we were having a hearing, and I was with him on the bench. The phone started buzzing, ringing, but you're in the courtroom, and some rules still apply. Even if you're with Judge Carter, you dare not pick up that phone. I dare not even glance at the text, but I wondered what was going on. We had a short break, and I got the first text that day, I want to say 10:50. Fire gets set for possible evacuation. My wife is at home, my son is at school. My wife rushes to go get my son from school, and I'm standing by for the all clear. We live in California, we live in Los Angeles, we've been through this drill. I've gone through the PG&E fires, the Thompson's fires, the Woolsey fires. Virtually, I can't name the number of fires I've gone through. At this juncture, you have to understand, for those of you who are not familiar with Los Angeles or the West Side, the fire is still miles away up on the Santa Monica Mountains. And so there's smoke rising. The winds haven't really picked up yet. And so you're not overly concerned at this juncture. There was a weather alert in advance, so you hope there was pre-positioned fire resources. People respond very fast in this area because fires can catch. And we've learned from lessons, right? I mean, PG&E was not that long ago. Woolsey was not that long ago. Woolsey was next door to the Palisades. When we say Woolsey, Woolsey was essentially Malibu, which is adjacent to the Palisades, again, for those of you not familiar with Southern California geography. So we wait for the all clear. Not coming, hearing continues. By 12:37 that day, I got my second text, that at least that I could look at. We left, evacuation chaotic. Please call as soon as possible. You've all heard about the stories of the evacuation from the Palisades fire. Pretty bad. I could regale you with the stories of the evacuation from Paradise, and they were horrific. So this time will be different. Reality arrives a little bit later that afternoon. The reservoirs that were there for wildfire fighting purposes are empty. 2 reservoirs, both not available. The fire hydrants run dry. The winds pick up. The aircraft is grounded. And we are glued to the local news. We had escaped down to Orange County, about 60 miles south. Went to my mother-in-law's house, and we're watching the local news. We're glued to it. We're also fixated on a text thread that runs for our street. We're watching the house on the outside cameras. Oddly quiet. No fire trucks, no firemen, no sirens, just flickers of yellow and red in the background. About 10 o'clock that night, the security company calls and texts. Alarms are activated, cameras go dark. What had happened earlier that day on our street, I told you there was a text thread. We had a fire captain, and he had texted, say around 5 o'clock. Fear not, the fire will never make it down the mountains, will never make it down to the town center. We live 10-minute walk to the town center. It will never jump Sunset Boulevard. We're not in a, and you'll see it in a little bit, but we're not in a sort of wildland urban interface. We're urban in the Palisades, at least where we lived. So we're in shock. I call a friend who's in the media, and they go the next day to check on the condition of the house, right? Hope springs eternal. And so this is my house, pre and post fire. Now, a picture is worth 1,000 words, and then sometimes it's not. So on January 8th, the next day, first we count our blessings. We are safe, we're together, we're fortunate. But it was not just things that burned up. You heard Lexi talk a little bit about what the victims say. You know, it was family heirlooms, it was old photo albums from Iran and India, from the old country. My fault that we had not digitized them, I guess. But they were lost. The last surviving items of my father, ashes. My son's ceramic footprints that we used to hang on the Christmas tree, gone. But again, ours is just one story. In the neighborhood was Annette Roselli. Annette Roselli, a kind, gentle, elderly woman who first greeted my wife and my son when we moved into the neighborhood, gave them the warmest embrace you ever saw. She died in her driveway. Neighbors lost everything. Families were displaced, lives turned upside down, or lives ended. Wasn't just our street, wasn't just our zip code. It's one of the most catastrophic wildfires to hit California. If you go to the Palisades, it's apocalyptic. In fact, the city council, just in its wisdom, it's 6 months now since the fire, just in its wisdom recently, has prohibited disaster tours of the Pacific Palisades. And so when tragedy strikes, the numbers dominate the headlines. 25 billion in damage, 7,000 structures, 12 lives lost. But they're more than data points. And I just want to remind everyone that there's a heartbeat, a home, a family. behind each of those. Now, it's easy sometimes, and I've been prone to it as well, for the law to lose sight of that. You know, we are so used to approaching things in an analytical, rigorous way. We evaluate claims, we evaluate evidence. But I would argue that it's in times of catastrophe, having mediated these and now gone through them, and again mediating fire cases, if you can believe it, that our justice systems are tested. Not necessarily by how quickly they assign blame or not, but I think by how quickly they can restore hope. And I feel it firsthand now. And Lexi said something. Many members of the federal family were affected. Many of you know people. Walking home from the civics presentation yesterday, I was talking to an old colleague about how he lost his home. Dinner last night, I was talking to another colleague, again of the Central District, about how her and her family lost her home. So it's here. The disaster is at the Ninth Circuit Conference. So before the first lawsuit filed, it's practical chaos. You're in shock, you're in awe. There's dozens of stakeholders, government agencies, private entities, public voices, each with their own interests, agendas, and everything is just fractured. Delays inevitable. The media, from national newspapers to local newspapers to social media and podcasts, ranging everything from public outrage, the mayor was in Ghana, to acts of heroism. You know, the firefighters were fighting the fire. It's not an indictment of anyone fighting their fires. My point being, the fact and fiction are interwoven for attention, for eyeballs. And nobody's really sure what to do, especially when you're all underwater or everything is ashes. But pause there again and ask, where are the victims? I was telling another colleague, you woke up on January 8th, and you're like, I had a suit, but I didn't have any underwear and I didn't have any toothbrush. So Target, here I come. Lucky, I guess, in that sense. But not always. The insurance company has asked us to immediately call the insurance company, and the insurance company has asked us to inventory everything we've accumulated in that house our entire lives, then put a second column for the date that you acquired it, and can you do a third column for the present day depreciated value of that? I'm going to get on that right now. Yeah. And I think the thing that broke my heart, my son was dutiful, doing his part. He heard us in the car talking about it. Grabs my yellow legal pad and starts inventorying his games, his Lego sets, his books. He told me the other day he was the only one that completed it. I'm writing letters to and imagine if you're not a lawyer. My wife happens to be a fortunate lawyer, and we're writing a letter to the insurance company every 2 days. But imagine you can't do that. A lot of people were multi-generational in the Palisades too. It's very challenging to be able to, to go toe-to-toe with an insurance company shortly after the disaster itself. By the way, that's if you're lucky enough to have insurance. A lot of people didn't. So we're still counting our blessings while we're going through this. Then comes the legal maze. I don't know if anybody can recognize it. It's not to the Ninth Circuit, but it's justice delayed is justice denied. Individuals filed claims. Some alone, some consolidated, some in class, some stayed, some not. All that becomes evident is that the proceedings are going to span years. And judges, very challenging. Stitching together thousands of fragments of arguments just from the beginning. Venue, standards of proof, claims or new claims of application, right? We talked about inverse. We thought we knew what inverse meant. Maybe it means something else. We were talking about opioids earlier, nuisance. We thought we knew what that means. This is just a motion to dismiss, or in California, the demur. What about discovery, experts, summary judgment, trial? And so what it becomes is, it's like this flood of paperwork, but it's more than that. It's like a flood of grief, of frustration. And where do you look? You look to the justice system. So you will inherit the disaster. But, as grim as all of that sounds, I think we heard yesterday, I don't know if anyone's present, life is hard, wear a helmet. I think I'm going to be using that all the time in mediation. There is a path. And I would argue that requires more than rulings. It's less about gavel pounding and more about bridge building. So look at the aftermath of the Maui wildfires. Global settlement within a year after the fire. Now, there's some hiccups, there always is. But when I think of the Maui wildfires, I don't think of ADR. I think of ADR plus. And I could call it ADR 2.0, which we would have done 10 years ago. But it is something more. And the plus is not just about, another streaming channel. It's about doing more. And I want to submit it's about, and I'm going to be careful with the words here, judicial oversight of the ADR process. Listen, it's not about, and when I was on the bench as well, it's not about putting your thumbs on the scale. It's not even having the trial judge get into the sausage making of bid and ask. It is not that. It is instead, and I think this could be the most valuable tool in the face of a disaster, is creating a resolution ecosystem that can act on its own, that can flourish, learn from its mistakes, self-correct, and provide a path forward. So what do I say that takes? I say it takes at least three things. One, structure. I think judges can drive early resolution. And you heard me talk about Judge Carter a little bit, and that's one part of it. But another part is appointing early mediators and special masters, creating a structure. Why? Listen, disasters at scale, and damages are in the billions of dollars. We're talking about defendants that may have to go into bankruptcy. So those are going to be tough cases to be settled anyway. But it's precisely because they're so challenging that the conversations have to start sooner. They have to be sustained, often by an outside force. It's not just putting a mediation cutoff date in a scheduling order. And let me give you an example of this. When we did PG&E, I was one of four mediators that first day that showed up. We had 150 lawyers. Wow, it was a mess. There was no structure in place. But that's okay, because you know what? We got together, we figured it out, we regrouped, we created different tracks. You heard a little bit, we heard about subrogation settling first. We created public entities, subrogation, individual plaintiffs, and we settled them one by one. Ultimately, the victims ended up with a $13.5 billion trust fund. And so we found the path there. Would have been nice to have some structure earlier. And I apologize for saying this. Judges can help create the structure. We rely on the lawyers to create the ADR structure. Sometimes they're good at it, sometimes they're not that good at it. But we can help, or you all can help in that process. Communicating value drivers. So when we have a regular case, it's always, I used to have in my script a regular comment about ADR. I want an early mediation cutoff date and an later mediation cutoff date, at least at the trial court level. And then we would say, obviously, to the plaintiffs, guaranteed results versus an unpredictable verdict. Bird in hand to ambush. Hey, defendants, watch out. More nuclear verdicts, avoid massive liability, mitigate your risks. Go resolve this. I don't need to tell you, but in the Central District of California, when I was there, we always used to joke about how, lawyers sometimes joke about, 2% cases go to trial. I think the last year I was at the Central District, we were having something like maybe 0.5%. And those were certain kinds of cases, indeed, certain civil rights cases that necessarily had to go because of different circumstances. So we know they're going to settle. Let's help them get there earlier. In ADR Plus, in disasters, you have other incentives. Defendants want global peace, not the slow drip of settlements. ADR Plus can be the architecture to get you there. Disasters have other components. You got to rebuild. ADR can help you rebuild that necessarily a jury verdict can't do. A jury verdict isn't going to get the above ground wires placed down below, but we can put those together. Let me talk a little bit about Woolsey. In Woolsey, what we ended up doing is not having the individuals didn't end up having a trust fund administered with $13.5 billion. What we had to do for that was mediation protocol, which we created from another fire that had happened, probably 10 years before in San Diego. And what that was pools of plaintiffs going through the process of settling it each at a time. Why? A bespoke approach fit for that particular case and that particular defendant. And you would get on the mediation, and I would have them, you would hear you're mediating the dispute, so you're hearing obviously what the defendant wants to argue about, but you need to hear the victims and their loss. And that was bespoke and fit for those cases. And it worked, and we got through Thomas and Woolsey. I don't think it's completely done yet, but that's there. One size does not fit all, hence the plus. It's not just a mediation you go to, 8 hours you settle that day, and some number runner goes back and forth. It doesn't work that way. Demanding urgency, number 3. Putting a structure in place, communicating value drivers, and then you got to create the urgency. So we like to chuckle when we say trial date settle cases. It's trite, but it's true. And I don't mean simply putting together a rocket docket. There's due process concerns for doing that, but it's mostly creativity and adjudication. Sometimes you might have some gating threshold issues. For example, in Woolsey, settlement talks didn't really mature, and I keep using the shorthand for the fires, the Woolsey fires that affected a large part of Malibu. We didn't have settlement talks mature in there until one of the judges sort of explicitly finally said, I'm not going to dismiss an inverse claim at the pleading stage. It was really only after that that the defendants had a line of sight that says this is not going out early. And that allowed us to get there. Again, just one of the tools that you have, bearing in mind due process, of course, always. But rulings that cure important information deficits in a disaster are invaluable. So what do we really seek after a disaster? Financial recovery, for sure. Structural rebuilding, of course. Something more profound, less tangible, trust. Trust is not rebuilt by accident, it's rebuilt by resolution, closure, peace. Through processes, like I was talking about the mediations of each of those, that's where justice is seen, felt, you're a part of it. And that comes through ADR, or in our case, ADR plus. ADR will resolve a case, ADR plus will resolve a crisis. So let me finish where I started. I never thought I would be the victim of a natural disaster. I assume many of you don't think you will be. But the world has changed and continues to change, and it's a looming risk for all of us. You heard me talk about the federal family that's affected as well. So particularly important for everyone in this room, in the face of that disaster, we have to ask ourselves, how will we deliver justice? Thank you, everyone.
Thank you very much. I'm very pleased and honored to be here and excited to be here at the Ninth Circuit Judicial Conference. My excitement has been tempered somewhat. About 3 weeks ago, I saw my daughter, and I said to her, Leslie, in your wildest dreams, did you think that your father would be addressing the Ninth Circuit? And she said, Dad, in my wildest dreams, I don't think about you or the Ninth Circuit. But I am pleased to be here because the Ninth Circuit is where I have been very, very fortunate to deal with mass catastrophes in and outside of the courts. Judge Breyer has put me to work over the years, and his technique with mass catastrophes is the docket. Trial dates, inviolate, won't be changed even by consent of the parties. You want to settle? Settle. Here's the window. Judge Chen, who I've worked with, he brings the litigants in mass catastrophe into his chambers with the mediator, no transcript, no recording, and Judge Chen says, ladies and gentlemen, if you want a trial in my court, you're going to get a trial. But think about it. Feinberg is here. Why not control your own destiny? You'll get a trial and a fair trial. But I must say, I want you to know that's an option you ought to pursue. Judge Shabria goes even one step further in his court. He's got the MDL Monsanto herbicide cases. He issues a public order, the infamous Order 240. And that order, which is docketed, says everybody who has a claim in the MDL must go talk to Feinberg and see what he will provide you in the way of a settlement amount. You don't have to take it, obviously, it's voluntary, but your ticket of admission to continue in the MDL, you must at least hear what Feinberg has to say in the way of dollars. 75% of the MDL cases that have come to us, Feinberg, as mediator, claims resolution expert, have settled. And otherwise, he'll send those cases back to the transfer court where they still linger to this day. So there are different techniques that constitute creative case management. Breyer, Chen, Shabria, the ones I've worked with. In LA, we settled with court approval, I think over 1,000 sexual abuse cases involving minors who were abused by the Catholic Church 50 years ago, and we got them settled. So there are techniques, case management techniques, that I look at with pride to be part of that. Now, all of these mass catastrophes that I've worked on over the last 40 years, 45 years, they're all different. My fellow speakers here are right, they're all different. But there are some basic agenda items that govern in every one of those mass catastrophes, and you can check them off like a checklist. I see them over and over again. One, Is it a standalone claims program like 9/11 was by statute? Federal statute created no courts, private standalone company, claims program. The BP Deepwater Horizon standalone claims program must be created by BP as the responsible party for that explosion. General Motors, the ignition switch problem in those Cobalt automobiles, General Motors, urged on by Congress, standalone program. But even in those standalone programs, you see the courts are a tremendous coordinator with what I'm trying to do. In 9/11, Judge Alvin Hellerstein in the Southern District of New York brought in all those claims from the World Trade Center and the airplanes. And he said, look, you can have a trial, but are you sure Feinberg's been set up here by Congress to pay you unlimited generous dollars? Why? Why would you? 97% of all eligible claimants came into the program. The BP oil spill, the judge in New Orleans told everybody, I'll give you a trial on the oil spill with BP. Are you sure? Feinberg's got this program that BP set up, and why? Why wouldn't you go to that 92% came into the program. General Motors, 96%, where the courts sort of urge, get these cases off the docket, you see. Something like that will be done with the Los Angeles wildfires, you see. Something will be done by that. So that's where the courts and these standalone programs interface. How much money do you have? You know, it's all about money. And in these programs, when you have a 9/11 program, all taxpayer money, unlimited, whatever Feinberg thinks is appropriate to get the cases out of the courts voluntarily, pay it. We'll authorize whatever it takes. $7.1 billion, 97% came into the program. BP, President Obama, BP, I want you to front $20 billion over 5 years. 92% of the claims came into the program. In 16 months, we paid out $1.6 billion before the first trial was even scheduled. In GM, I don't know, $600 million paid out of pocket by GM, 96% of the victims paid in. So if you have enough money, and if it's unlimited, it gets a little testy, you see, if you're taking from Peter to pay Paul to stay within the limits. But if you have the argument to a claimant, we're not cutting you short because we have to save some money to pay B, C, or D, then it's just a lot easier to get over that hurdle, you see. How much money? Where is it coming from? Is it a standalone or is it in coordination with the courts? Very important. Who's eligible? Big issue. Who's eligible? Some people in BP say, I should be eligible even though I was 50 miles away from the spill because I was impacted adversely by that spill in terms of tourism, etc. You got to deal with eligibility. And when you deal with eligibility, here's a tough one. I've learned over the years, you must resolve now all latent claims that may not come up for another 20 or 30 years before they manifest an injury, asbestos, for example, or oyster beds or shrimp harvesting in the Gulf. You've got to have a program now to estimate. That's where the bankruptcy courts play such a role today in mass claims. You've got to estimate future peace, the future number of claims, so that the company or whoever's paying the freight is out now and doesn't have to worry about claims dribbling in for the next 30 years. That caused 94 company bankruptcies with asbestos. They couldn't estimate the number of future claims. You've got to do it now as part of eligibility. What's the methodology for calculating individual awards? That can be pretty complicated, but notice this. If you're dealing with a program like 9/11, all current claims, or if you're dealing with a program like BP where there may be estimated future latent claims, you see, they're an alternative to the tort system. So you've got to figure out a way today to calculate in your methodology, here's what we're going to pay current claimants, and we've reserved X dollars for future claimants. You've got to do that because no one wants to settle cases now and not get total peace. And you can't do a class action anymore because the Supreme Court won't let you. Well, now you've got to look for a forum to aggregate the claims and come up with a dollar value for current and future claims. The bankruptcy courts are swamped with these cases now because there's no class action. Judge Chabria can't help you in the MDL as to future claims. You got to come up with some creative solution now. That's the methodology issue. Then there's the whole issue of proof. Prove that you've got a methodology sound eligibility claim. That's not so easy sometimes. In the church cases, you've got minors who were abused 50 years ago have no proof. I was abused by Father Jones. If you're going to pay me, it's going to be based on the proof of circumstantial evidence. I was abused around 1960 or 70 by Father Jones. Well, it just so happens we have proof that Father Jones was in that diocese and abused 7 other kids. You're eligible. But you got to have proof. Now in BP, we received in 16 months 1,250,000 claims. I never heard of so many fishermen in the Gulf of Mexico. They all came in. And a fisherman would come in and say, I couldn't fish. The Gulf was closed. I lost $10,000. Pay me. And I would say, Mr. Fisherman, if you have got a claim for $10,000, we will pay you. Show me your tax return. Tax return? I waive it. You can't waive a tax return. I've got to see the tax return to conform to your $10,000 demand. Never filed a claim. I said, we can pay you, but you'll have to fill out the form. We'll have to report it to the IRS. You're going to report my $10,000? I withdraw my claim. Never paid taxes. So you got to have a proof requirement of somehow to corroborate what would otherwise be an invalid claim. Then there's the timing. These programs must have a limit. They must. In 9/11, by statute, 33 months, the time you file a claim till the end of the claim. That's it. The program's over. It will not be extended. Everybody, 2/3 of the 9/11 claims came in the last 5 months. People hem and haw. They wait and see what their neighbor got. Then they decide. And when they know there's a deadline, do not extend these programs. They'll hem and haw further. You got to bring an end to the claim program. Then there's the question of due process. Now, in 9/11, as some of you know, we gave anyone who wanted a private, confidential hearing that opportunity. I personally conducted 950 individual, private, confidential hearings among very angry, depressed, frustrated claimants who lost loved ones on 9/11. That was debilitating. That was the toughest part of the program. So soon after the tragedy, having people come in and tell me their tales of woe, which were, better be a rabbi or a priest than a lawyer for that. Better I have a degree in divinity than law when you're talking with victims who lost loved ones. But due process was critical to the success of these programs. You couldn't have a hearing in BP, not with 1,250,000 claims, but with 9/11, with General Motors, with all of these programs that aren't alternatives to the tort system. One Fund Boston Marathon bombings, the Virginia Tech shootings, the Aurora, Colorado shootings, the Pulse nightclub terrorist attack in Orlando, Florida. We gave every one of those people an opportunity to be heard. It makes the difference, you see. And when courts have an opportunity for either on the record or even better private chambers hearings or discussions with individual victims to let them vent, and you explain as a jurist why it's important for you to consider generous settlement dollars, it makes a difference in terms of the acceptance of these programs. The final sort of preliminary point I want to make, people ask me all the time, what is the toughest part of these mass catastrophe efforts at resolution? Is it calculating the dollars for a claimant? No. Judges, juries, courts in every state in our union do that every day, economically, right out of the tort handbook. Economic loss, pain and suffering, emotional distress equals the value of a life. It is not rocket science. It is sometimes rough justice, but it works. It works. The problem is, for me, and I think for anybody involved in settlement effort of mass catastrophes, the problem is the emotion. And sometimes you think like you're Solomon. When people come in, I'm just going to give you a couple of examples. Last night at dinner, I gave a few examples. But I want you guys to understand the emotional overhang that prevents, I think, most people from doing what I do. Because the relatively straightforward path, I think there are many, many people in this room that could do what I do. But you better brace yourself in a mass catastrophe as to what you're going to hear from individual claimants in confidence. 9/11. 3 examples from 9/11 when you hold a hearing. A woman comes to see me, 26 years old, and she's sobbing. And she says, Mr. Feinberg, I lost my husband at the World Trade Center. He was a policeman or a fireman. And he died on 9/11, and he left me with our 2 children, 6 and 4. Now, you're going to give me $2.8 million tax-free. I want it in 30 days. Well, Mrs. Jones, why do you need the money? This is taxpayer money, Ms. Jones. The U.S. Treasury will take its bureaucratic time. You'll get it within 90 days, but you'll get it. No, 30 days. I said to her, why do you need the money in 30 days? Why? I'll tell you why, Mr. Feinberg. I have terminal cancer. My husband was going to survive me and take care of our 2 children. They're going to be orphans. I've got 8 weeks to live. I need this money. I got to set up a trust. I've got to get a guardian ad litem. I've got to assure their schooling. I don't have a lot of time. Well, we ran down to the Treasury and processed that check. And 8 weeks later, she died. And every day, stories like that. Another woman, second of 3 stories. Another woman comes to me, Mr. Feinberg, I lost my husband. He was a fireman. When the planes hit the World Trade Center, he ran into the lobby and rescued 20 people and brought them to safety. He saw that another 20 were trapped. He went back into the building, brought them to safety. While he was running to escape across the World Trade Center plaza, he was struck and killed by somebody who jumped from the 103rd floor of the World Trade Center and landed on him, killing them both. Don't tell me there's a God, Mr. Feinberg. Don't tell me no God would allow my husband to die that way. That's the second story. And now the final one, and one that I leave you with to decide how you would decide this one. A lady comes to see me. I thought she was going to collapse in my office. Mr. Feinberg, I lost my husband. He was a fireman at the World Trade Center. and he left me with our 3 kids, 6, 4, and 2. My husband was Mr. Mom. Every day that he wasn't at the firehouse, he was home, teaching the 6-year-old how to play baseball, teaching the 4-year-old how to read, reading a bedtime story to the 2-year-old. And what a chef! He cooked all our meals. He was the gardener around the house. He was Mr. Mom. Mr. Feinberg, you're going to give me $4 million? The only reason I haven't gone up to the roof of our home and jumped to join my husband are the kids. But it doesn't matter how much money you give me, I'll never be the same without my husband, Mr. Mom. She leaves. The next day, I get a telephone call from a lawyer in Queens, New York. Mr. Feinberg, did you meet yesterday with Mrs. Jones and the 3 kids and Mr. Mom? I go, yeah, I did. Now look, Mr. Feinberg, you've got a tough job. I don't envy what you have to do. But she doesn't know that Mr. Mom has 2 other kids by his girlfriend in Queens, and the girlfriend has 2 children that need to be reimbursed by your fund. And you know, I don't know what you're going to tell her, but I'm sure you'll do the right thing. Click, he hangs up. Do you tell her? This isn't a legal question. This isn't something for the Ninth Circuit. This is a rabbinic question. Do you tell the woman about, you know, there's always some lawyer in the audience, did you take the DNA? Forget, yeah, it's all taken care of. Do you tell her? Do you tell her about the other family that this guy was living with? We went around and around on this. We decided at the end of the day, no, we're not going to tell her. We cut one check to her and her 3 children, and without her knowledge, we cut a separate check, second calculation, for the girlfriend as guardian of the 2 kids. Now that was what? Almost 25 years ago. They may very well know now, but we weren't in any position, we felt, to get into that with some of the emotion that we had to confront. So that's sort of a summary of mass catastrophes, whether it's a standalone type program or a judicial sponsored program or sort of a coordinated both program. Early settlement, in my experience, always better. Creative case management, Breyer, Shabria, Chen, very important. Ninth Circuit seems to be ahead of a lot of others in terms of trying to deal with this type of thing, and honor and a privilege. Thank you.
In the recent wildfire tragedies, many victims were skeptical of FEMA and the federal government. Some of the communities that suffered the greatest tragedy also experienced widespread misinformation about what FEMA was doing for them. Have conspiracy theories and/or government mistrust impacted your ability to resolve these kind of cases?
Too early. No. The wildfires? Too early. I have no idea. I doubt it. I doubt that conspiracy theories, when it comes down to whether or not you're going to get paid and how quickly you're going to get paid, I think that probably, no pun intended, but that probably trumps everything else.
How do things change when insurers pull out of regions entirely and insurance becomes unavailable to potential victims of disaster?
The whole dynamic changes, right? I mean, first of all, you've got, in the Palisades was a common situation. I think Eaton was same, Altadena. State Farm, for example, the largest in California, had canceled quite a bit of policies. State Farm did reinstate some of those policies. The question is going to be, after people rebuild, are you still going to be able to get policies, and at what cost? I will tell you an interesting story where I was buying the home there, and I couldn't get policies at first, and my insurance broker had me go to Lloyd's of London to have a custom written policy for fire at the cost of something like $25,000. that, that's a little pricey. So it's going to be a huge impact. State Farm has come in now and saw rate changes, and I think our insurance, I want to be careful talking about the California Insurance Commissioner, but he's got a tough job balancing, what happens in that arena. We need insurance.
It also affects the bankruptcy risk that the defendants face, because if you don't have insurance to cover parts of your losses, then you seek to recover all of them from the defendant you're suing, the utility, in many of these wildfire cases. And while we do have this backstop bill now in California, where if the utilities have paid into a fund over time, and if they are found to be sort of merely negligent and not worse, then they can avail themselves of this fund. We are already at risk this year that if another fire occurs, we will exceed the amount of that fund. If we were in the situation we are now with insurability in Southern California, for the people who lost their homes in the Eaton and Pasadena fires at the time, we definitely would exceed it. We may not, because many of those people were insured, but they're now having to find new homes and often being told that they can't insure them at all.
Do you have a sense of when claimants opt out of the claims process? Do they generally do better, the worse, the same if they go to trial?
Well, first, very few opt out, as I've said.
Yeah.
If the program's set up right, very few opt out. I don't know, I think probably they do about the same, although they have to pay what? A third or 40% to their lawyers, which has to be netted out, and they have to wait longer, which is a problem emotionally, I think, about getting money quicker and with certainty. But so few opt out that we don't know. It's all confidential. So
We've seen very few trials in wildfire cases, even in a program where we designed resolutions such that liability was essentially stipulated to, and only damages were the subject of mediation. And if your mediation failed, you then could go to trial on just damages. This is the Woolsey and Thomas program that Judge Gandhi was referring to earlier. Even in that context, very few have arrived at trial. There are those who go extremely close. And again, I think that's a trade-off for people in terms of the time without the compensation, the time with the emotional investment in your case and the uncertainty. But getting close to trial always has an impact on negotiations.
In some of those Woolsey ones, we had seen people do actually worse. In the mediation protocol, you first had a mediation, then you went to this binding protocol where there was only like 3 or 4. I was one of those designated ones, and at that point, the mediator can almost decide. You just decide. It's almost like a quasi-arbitration of what the amount is, and some did worse.
If the district court wants to facilitate a claims program and a complex mediation ADR environment, how do they ensure that the professional claims administrator and the mediators get paid through that program?
how do they assure what?
That the professionals, the mediator, claims administrators get paid through that program.
In the cases I'm involved in, the courts say work it out between the parties, and don't come to me. I'm not a bill collector. I'm a federal judge. Never go to the bill collector. Work it out.
When we've had mediation protocols like the ones we were just describing, each case that opts into that program is assessed a portion of cost for it. And if they don't initially resolve and decide to go to additional stages, those costs may increase. So that's one way of handling it. In a context that's more like a multi-district litigation, there may be common benefit assessments that are paid that cover the cost of mediation. Those would be two ways.
The lawyers are pretty good at the cost sharing.
Yeah. If there's one thing you could change in the judicial process following a catastrophe, what would it be?
If there's one thing, I'd urge the Federal Judicial Center to have Breyer, Chen, and Shabria educate new judges on some creative case management techniques, because I think the techniques are there. They're adopted by various judges serendipitously, depending on the judge's philosophy and what he or she thinks is appropriate. But there's some pretty creative case management out there now to deal with mass catastrophes.
I would say there can be a suite of case management orders that can be put in place quickly in these cases and can facilitate moving forward quickly. And as Ken was saying, you're not necessarily reinventing the wheel. Those case management orders exist from prior cases and could be adapted. But these are things like getting the basic facts of each case sort of in the door of the judicial system and to the other side, meaning what kind of claim are you? Are you a total home loss? Are you a tenant? Are you a business? Are you a personal injury or wrongful death? Getting basic information from insurers. And then on the other side, so that we can facilitate the discovery process, things like protective orders and ESI orders. These, as I said, exist in the context of fire cases specifically. And so having those just ready to go with the court urging the parties onward, I think, is one of the best ways to kind of short circuit a lot of the initial chaos.
I would just, it's the same thing as Lexi, but I always thought of this. You know, when we have those patent cases, right, we would do a tech tutorial of the day like that, where it's not just evidence-based, just kind of just give us the sort of the landscape of everything that's going on, talk to me about the tech, talk to me. You could almost have a disaster tutorial, and then you have exactly what Ken was talking about with Judge Breyer, Judge Fabio, Judge Head, active case management, which has been encouraged, right, by the AO for a long time, and then keeping ADR top of mind. They're going to need a path to resolution.
Do you anticipate artificial intelligence serving as a useful tool in the claims procedure and administration process?
That's the next generation's issue. Again, you might try Breyer, Chabry, or Chen, but I don't know.
That's intelligence, not artificial intelligence. I would anticipate AI being a tool. How useful it is, I think, remains to be seen. We have all heard a lot about both advantages and pitfalls, and I think we have to be aware of both. I think it's actually already in use by claims administrators, whether they tell you or not. So it's probably an inquiry that we as lawyers need to be actively making, and the judiciary may want to make as well.
AI is coming. We'll wait for the next panel to explain to us exactly how. I feel like I should drop a footnote here, which is all the judges of the Northern District of California are brilliant.
What impact does litigation funders have on resolving mass torts?
I read a lot about it. I don't know the answer to that, except it obviously is at least an existential concern. I don't know how judges handle that issue in terms of disclosure or requiring more information about funders, but it's obviously a big issue.
I'm going to be a little bit of a contrarian here and say I think it's a lot less of an issue than the courts may be thinking it is based on the feedback we're getting. And I will caveat this by indicating that my firm does not use it, so I don't have direct experience with it. But I feel like there is the sort of specter being raised out there of these are outside people who are controlling claims and who maybe don't have the actual litigants' parties' interests at heart. I don't want to say that can't exist. I do think it's exceedingly rare. And so I have a concern that doesn't pertain to my own practice personally, but I have a concern that it's become something of a boogeyman that it isn't quite warranted to be. I have not seen it play any major role in these kinds of cases.
So this is probably where Lexi and I disagree. I've seen it. I've seen funders. Now, listen, not every firm is Leif Cabraser and can self-fund. So smaller firms have gone to litigation funders. But there's something else that's also happening that's very interesting in natural disasters. There's another type of funder, the private equity firm. And private equity firms are picking up claims. In fact, there's been a lot of headlines of them, just the recent wildfires, picking up claims from Subro, from carriers. I can't remember, but like 13 cents on the dollar in Palisades and X number of cents on the dollar in Eden. And you know what? They were an issue in PG&E when we were trying to settle. I was involved in trying to settle Subro there.
I think that's the first time we
Yeah.
saw that, and I absolutely agree on the hedge fund private equity angle. And this isn't what most people think of as litigation funding, so I'm glad you're flagging it.
Yeah.
This is a totally different kind of funding that often is not for plaintiffs even, although it can be. And it has been in the backdrop of these massive cases. And so the lawyers that we all may be accustomed to working with or seeing in courtrooms may not even be fully aware of this component of it, but it has reared its head in a number of cases. It's not your typical litigation funding. It's not the settlement loan. That's not what this is.
On behalf of the Conference Executive Committee, it was a pleasure working with you, and thank you so much.
We can't.